We are quickly beaming into this session. I think the last panelist is coming in and it's right now. I'm thrilled to be joined, and certainly if you've been watching during the course of our day, I'm thrilled to be joined by this panel, and always in the world of sports today, but particularly college sports, the phrase "Yes, there will be lawyers" will always be true. I'm going to introduce everybody quickly. We'll kind of come to everybody in a second, but I wanted to say something about everybody. Then we'll kind of introduce into their work with some questions and dive into this topic. Clearly, college sports right now is in a functional flux, maybe upheaval because of its legal status in any variety of directions. We're joined by an extraordinary group of panelists. I'm going to take them from my farthest away from where I'm sitting. My former colleague at Ohio University, who took over the classes there when I left, but a lawyer who's also married to an NCAA compliance director, so he gets to share both and has worked in that space too. Former college athlete and wonderful guy, Brandon Wright. Next to Brandon, I think of Andy as simply the economist in sports. And he does work on pretty much every case there is out there. Based in the Bay Area, Andy's company is one of the most influential in terms of sports economists in trial work and in other cases. And Andy's vision and view of things is so extraordinary, and I'm happy to have him. Debbie Spander is one of I would say almost the lawyer's lawyer in this space. She has worked at networks. She has represented individuals in this space. She's been an NIL educator. She has been in sports for, she looks much younger than this, but a long time. So we won't know how she's doing that, but it's an amazing thing. And she grew up in sports as the daughter of a legendary sports journalist. So I think it's a particularly wonderful thing to have Debbie with us, who brings this such of a range of experience representing individuals, institutions, and entities in this space right now. And her voice is so fresh and interesting. To the top, my colleague from New York, who I get the benefit of having about a quarterly lunch with, Mark Edelman, is well thought of. His brief work, whether as an amicus or law review article, has been cited very favorably in all the big cases. Mark is an expert in two things that are so of the moment: the antitrust nature of college sports and the law, and then also to some degree the legalization of sports betting, another concurrent subject. So I'm thrilled to have him. On the top nearest me is Professor Michael Leroy, who I have admired for a long time. I've only had a chance to talk to a couple of times when I was teaching at Penn State's labor school while serving as the athletic integrity officer there. Michael's work is some of the most outstanding work I've seen in this space, both as a labor expert and an attorney and a scholar. So his meaning and power in the idea that we're entering into a world of professionalized labor relations potentially. There's nobody more relevant than Michael, and I'm the classic person who hates everything, and I've loved Michael's work. I have another Michael with me, my colleague at Shumaker, Michael Chapman. So perfectly appropriate that we have two lawyers on this panel from the firm that's sponsoring it, the place I get to hang out my shingle. So gentlemen and lady, we are all here talking about the current legal nature of college athletics. Where are we now? Jump in.
Who wants to start? All right,
Debbie,
I'll start.
Debbie, you go. Yeah.
All right. Yeah. I mean, I think we are in this really interesting and confusing gray area where some things are legal, some things aren't legal. Everything seems to be going forward at, 100 miles an hour. And then all of a sudden, we have athletes going into the transfer portal because they're not being paid what they claim they should be paid because there's no contract. So we are in this NIL area, which marketing, sponsorship, and licensing deals are legal. Pay for play is still illegal, but collectives are kind of paying for playing anyway. but then sometimes they aren't paying. And now we've got the house settlement maybe about to settle in the next 60 days. We'll see. So it's just a super confusing, interesting area where unfortunately fortunately there are some athletes making a lot of money off of their names, image, and likenesses and what they're bringing to universities, which I know Andy Schwartz is happy about. But there are others making nothing. There's others being promised and not getting the money. And, you know, we're about to have these guardrails that the NCAA and athletic directors keep asking for, even though they've been denying that the athletes are of value to the schools. And I don't call them student athletes, I call them college athletes, because that term was devised by the NCAA to avoid paying them.
I was an expert witness in a case against the NCAA, and I told them I don't use the student athlete stuff either. So in that same way, Mark, your work, probably a leading edge piece of this, and I think Debbie did a brilliant job kind of doing a summation of telling us our present state, that we're caught between a bunch of legal angles. Where should we be, Mark? Where do you see it? Because you've been advocating for an answer for a while.
Well, I think as confusing as we are right now in a place to many people, we are exactly where we should be, and exactly where we should have been for a long time. The thrust of my career as an academic, and a lot of my publications for the past 20 years, have boiled down to one point. And that point is that the NCAA, just like any other sports trade association, is subject to federal antitrust law and must comply with antitrust law. And my view was always based upon looking at what's now more than 130 years of jurisprudence of antitrust and its reasonable application. The NCAA for a very long time had operated under this legal fiction that it was somehow exempt from having to comply with antitrust law, relying at best on a small line of dicta from one case, and at worst on something entirely in their own head. The 2021 U.S. Supreme Court decision of Alston v. NCAA unanimously made clear what I always thought was the case, that the NCAA member schools, when they get together and engage in collective behavior that restrains trade, violate federal antitrust law. And there have been a number of cases since that have more broadly looked at restraints and put in place by the NCAA, including restraints related to direct pay for college athletes under the so-called name of name, image, and likeness as violating antitrust law. So now we're at a very interesting moment. The NCAA member schools have a few choices. They could comply with antitrust law, which means dropping about 90% of their rules and stop colluding in free markets, and that's one choice. They could separate into several smaller entities where none of them have market power, and thus the entities theoretically could each have their own rules and compete against each other without violating antitrust law. Or they could do what perhaps Professor Leroy will talk about, which is drop their opposition for athletes unionizing, allow the athletes to form unions, collectively bargain with the unions over mandatory terms and conditions of bargaining, and thus enjoy an exemption from antitrust law. Now, the NCAA at present doesn't seem to want to take any of these three completely reasonable and available options to move forward.
I'm glad you said that, not me. But yeah, they don't seem to choose any of those options.
The NCAA has chosen the silent option on the menu of number 4, which is to try to reach an antitrust settlement that will put in place some form of a salary cap and try to be able to avoid complying with antitrust law and avoid complying with labor law. In my view, the silent option is not a legal option, but there are 7 other people here, and perhaps they may agree, perhaps they may disagree.
I was struck by the front of your question where you said we have the legal status that we deserve, I feel like right now that we've earned, which isn't a particularly good one. And you did cue up Professor Leroy, who I did want to go to next, kind of out of that, because throughout the history of pro sports, at least the modern history of pro sports, interwoven is this kind of almost a DNA fabric of labor relations and antitrust and labor relations kind of as dual tracks. And I know that's sort of your area of expertise. Do you want to take a shot at kind of just sort of sharing that view and where you think we are?
Well, first of all, I'm struck by Debbie's terrific overview. I think she captures it tremendously well. And Mark has provided a terrific legal framing. So it's easy to sort of fit into that structure, Bob. You know, I would say that apropos Mark's observation that we are where we should be. If you look at the history of unionization in professional sports, we're tracking along the same path. What do I mean by that? Debbie mentioned that NIL pay is substantial for some and insubstantial for others. This House settlement, if it gets final approval, the core of it will be regulation of NIL so that only one's intrinsic value is compensated, not your pay for play value. In my view, this will result in a substantial reduction in NIL deals for the second string left guard at an ACC school who probably is making $200,000 or $300,000 in NIL money doesn't have any intrinsic NIL value per se. That person is going to be shortchanged. What I'm driving at is the NBA Players Association was the first union to have a wildcat strike. They had a televised NBA All-Star game. It was the first televised game. Tommy Heinsohn.
1964. Yep.
You got it. That's great. He's a Holy Cross guy who made it big in the NBA. They sat in that locker room as the minutes were ticking down to tip off, and they said, "You will sign this labor agreement, or we're not playing." And I think college athletics is highly vulnerable to this kind of wildcatting effort. I hope it doesn't happen. That's a poor way to introduce unionization. But you know, to Mark's observation that we are where we should be, to enlarge on that point, at last players are being compensated. But to Bob's point about, I don't call this student athletes anymore, and neither do I, the NCAA insists that this isn't pay for play. This is revenue sharing. They always have a, um, a, a, a phony term for what's going on. Okay. And again, even if the settlement goes through, I think they're forestalling the inevitable. The inevitable, and then I want to pass the ball here, is that to Mark's point, the easiest way to get an exemption from the Sherman Act is to have a collective bargaining relationship. There is something called the labor exemption. It's not just sports specific. It is labor specific, but it has profound implications for leagues and sports. If we remember back to 2011, there was a lockout in the NFL. And Tom Brady had a prominent role in the negotiations, and he and the NFLPA, they deauthorized their union. They deauthorized their union because they knew that they could not prevail on their key bargaining issues. They wanted to deauthorize their union, wave a wand, we're done with collective bargaining, and sue again under the Sherman Act, where they had 21 years of progress in achieving more free agency. And what I'm driving at is the Eighth Circuit Court said, you know what, Mr. Brady, you still have an employment dispute, and you can't proceed in a court under an antitrust theory. And so the quickest way for stability to occur for the power conferences would be to recognize a union. And there are several out there that are willing to step into that breach and say, hey, we'll represent players. And I would just add, and I have spent 36 years on a Big Ten campus. And like Bob, I have dealt with 18 through 22-year-olds, okay? I just think these leagues would have enormous bargaining power over these young folks. I mean, if you think about it, they've spent most of their lives learning to be deferential to coaches. They respect authority, or else they don't get ahead. And they're young. They want playing time. And they don't want to be sidelined. They don't want to be locked out. So I think that's hopefully we're going to get to a collective bargaining relationship.
Michael, I want to come back to you for two questions that you prompted that are both so good. There's still a lot of negative reaction to employment status. One from the institutions themselves, because it would change the rules. And two, there's a legal impediment, particularly over the reach of the NLRB in certifying unions involving public employees in a number of right to work states and southern states. It feels like are those impediments ones that are insurmountable here, or would there be a case in your mind where they could be overcome for the better good?
No, I'll be brief because I want to hear what our other panelists have to say. To your second question, excellent point. Roughly 85% of the power conference schools are public sector, and therefore they can only proceed if they have an election process under a state collective bargaining law. And many of the states don't provide that, especially in the South and the West. However, there's nothing that prohibits the NCAA or its conferences from entering into a voluntary collective bargaining relationship. Folks, before the 1935 Wagner Act was passed and before the 1926 Railway Labor Act was passed, where unions were strong in music in particular, musician unions were very strong, and they were radical, to be frank, but they got voluntary agreements without the benefit of a law. So it's a very good point you make. But again, these laws do not prohibit a union. If you want to go through the regular authorization process, you need to have a law that enables it. That's point one. On the second point, this Johnson versus NCAA case, which is under the Fair Labor Standards Act, it's a plain vanilla case. The antitrust situation, what Mark is talking about and is expert at, that's complicated stuff. That's very difficult to prove and determine what a relevant market is. This stuff on the employment side, the Third Circuit just came out in July, and they said there's a 4-factor test, but it involves control and who benefits from the control, and is there an implied expectation of compensation? And so I think that will eventuate in a ruling that some, not all, college athletes are employees.
That's a fascinating reality. Brandon, you not gonna hold you to play a role, but you've had a lot in this space, going from athlete to staff member to professor in the course of this. So you have a variety of perspectives. Could you share where we are in athletics right now and how far short of where we should be? Maybe we should, or where should we be headed?
I've got to agree with Debbie. The state of influx is something that I personally haven't seen in my time as an athlete, as an NCAA staff member, or working in the membership. And it's been fascinating from the academic side to consume it without having to be in the midst of it. It certainly, from my perspective, to answer the second part of your question, is getting close. I think this is some stability. I think Michael's point is a very, very good one. For a long, long time, I wasn't on the train of driving towards unionization for many of the reasons that he mentioned, that I thought that bargaining power might be a little bit too far in disparity to make it worthwhile for both sides. But I think clearly with the court's change in pace over the past 10 years, that's the most obvious pathway. The NCAA strategy of trying to get some kind of antitrust exemption doesn't seem politically viable. So I think at some point they're going to have to figure out exactly how they want to partition, as Mark mentioned, the legal statuses of each conference or each individual sport to end up in some form of unionization. I don't know how official that the NCAA or the member institutions are going to want to make that, but Michael's point of the voluntary nature of trying to figure it out is probably the best pathway. I hope that happens. The settlement, it looks like they're going to give them about 10 years. I would say 5 or 6 of those is your maximum before the pressure valves are a little bit too high up in order to stave off future litigation. But at this point, I think we have to recognize the realities of what we're heading towards, which is a full-scale model of professional sports within the college setting.
You made a really interesting point in that one. I thought that was that the idea that the hope to get Congress to take some action definitively to provide that antitrust benefit, at least right now, looks like it's not in play, probably.
Not the best year
Yeah.
to try to engage, and certainly not the best point in time to try to engage. I don't know if that's going to be the case going future. Obviously, we have to wait until after November to see if any of the pieces of legislation that are currently being offered through the Senate or through the House side have any momentum whatsoever. But I think the strategy of trying to use political forces and political leadership to change the direction of the NCAA is a little bit out of lockstep with the fact that most of the conference commissioners are now going to have some form of media background and are going to be all in on the train of, hey, let's figure out how to make this work because we're trying to generate revenue in any way that we can. And the big driver is going to be putting these athletes on TV and getting eyeballs.
That's a fascinating point and a great one. I want to go to Michael Chapman only to bring him in on this one, and feel free to ask questions as you go. And before I go to Andy to kind of give his view of where what we've just said, which I'm going to really enjoy. Michael, your background comes from the U.S. Center for Safe Sport. Safe Sport was created as part of the Ted Stevens Act. The Stevens Act was sort of an attempt by Congress ultimately to take over the Olympic movement, and it pushed the AAU out of the Olympic movement. It turned it into at least one that I won't say is athlete centric, but is at least athlete focused in some measure. How does your experience at Safe Sport and in that movement and working with our clients and NGBs how does that resonate when you think about the college space right now?
So we've touched on it a little bit. I think Michael touched on it a little bit. One of the things I'm curious to see is the breakdown and the separation and the distinction between, major college football, major college basketball, and some of these Olympic style sports, because I think you see it at the NGB level in terms of funding, in terms of support, in terms of how they're generating the revenue to continue to operate. I'm curious to see, as we head towards athletes are our employees, and I think we're clearly headed in that direction. It's coming. It's just how we get there. How does it all shake out? I think it's very easy to say at the football level, if you're at major college, if you're at the Big Ten and you're a football player, you're an employee. We know where that's headed. We know where that's going to end up. What I'm curious to see is further down the line, where does baseball end up? Where does swimming end up? Where does track and field end up? Because it's one of those things where it's real easy to say, when we have a really big pie because Ohio State's making hundreds of millions of dollars off its football program, some of that should be going to the athletes who are generating that revenue. Where do we end up when the revenue isn't there at the same level and with the same kind of force? And so I hear a lot of people talk about it, and I think it's very easy to focus on the big sports, the major sports. I'm curious to see of what's the secondary impact. Where's the impact for that swimming? Katie Ledecky is a little bit of a unique thing in swimming, of like, she would be unique and different, and how does that play out? Like, I think there are some fascinating questions where we have some general idea on maybe football and basketball and even men's basketball, women's basketball, even maybe baseball might be high enough up there, or some of those sports. But I really am fascinated on the Olympic sport side of things, of where this ends up and how this all shakes out. Because if everybody's an employee, I'm not sure that many schools are going to want to be playing the golfer or the swimmer that may not be generating the revenue that the football player is and that the basketball player is. So I love hearing about the big side. I'm kind of curious I think we're in a wait and see mode then on the secondary piece, which is we'll figure out the big sports first, and then how do we figure out the smaller sports? So
I'm fascinated by your response in that one, as somebody who thinks that there might still be a Pac-10, 12 or whatever, if Missy Franklin and Katie Ledecky could have swum against each other in a dual meet twice a year. that would have been televised in product, as opposed to both of them giving up their eligibility to turn pro, essentially, that no one faces that. And because I mentioned the pro word, Andy, I've come to you. You've heard from, I think we have 6 lawyers around you. You're the one person with a real skill and can add numbers in a column that we can't, because we wouldn't be lawyers if we could. Tell us, Michael, I apologize to you. You're also an MBA CPA, but so I can't lump you in that category. But tell us what your reaction to our conversation is, and take us in our next direction.
Sure. Well, I love being an amateur lawyer, so I think it's fitting that I work in college sports. I just do it for the love of the law. No one pays me. They can't pay me. All of you guys are pay for litigate and pay for contract review. It's horrible. I don't even know why people use you, because clearly anybody who's doing something for money is not doing it for the right reasons, right? I mean, that's the ethos of amateurism. And to that end, no, so of course I'm kidding. To that end, I'd like to add to the words that we don't use, of course not student athlete. I don't say pay for play, because it's designed to imply that it's a form of bribery, like when you pay to get your music on the radio, or you pay a congressman for a vote. I use compensation for athletic services, or just salary, or whatever. I think it's a much more neutral term. There's no need to buy into that. And similarly, and Debbie, I know you didn't mean this, you were just being shorthand. So this is not a critique of you, but just in general, paying somebody to come to their school and calling it NIL, but not requiring them to engage in any actual NIL thing, is not illegal. It may be violating the NCAA rules, although those rules have been enjoined by a federal court. So if anything, enforcing those rules is illegal. Again, I'm being an amateur lawyer here, but so I think if we want to say not permitted or something like that, as opposed to illegal. I'm just going through my list of notes here. I agree with you, Michael, that if there were a single NCAA bargaining unit and a single athlete bargaining unit, that would be the weakest athlete union on earth. If you look at what happened during COVID, there was a brief attempt out here in the West Coast for the Pac-12 schools, as they then existed, for the athletes to say, look, we don't really think you're putting our safety in consideration, and when we play, we don't want to play unless. And Larry Scott, bless his heart, in the Southern sense, said, well, great, we'll just cancel the season. That's called a lockout. And the moment he locked out the athletes, they started begging, we'll play, please let us play. And that's exactly what I think what would happen. And so if I were, and in fact I am trying, whenever I'm asked by any would-be union what they should do, the first thing I say is no bargaining unit bigger than the conference. If you imagine the SEC and the Big Ten having separate union deals, the SEC's incentive to push down pay to the minimum is really heavily mitigated by the Big Ten saying, we'll take you and we'll pay you more. And so you can have these great partnerships. And the bargaining unit here, I think, really is the conference, because the conference is the television program generator. And these are really television programs at this point, where they happen to have a paid studio audience. Making sure that you have your partnership. Look, yes, we'll partner with you and you give us a fair split, and then we're going to compete and be better than this other unit. And yeah, we'll play them in some championships and we'll play them during the season. But this is competition on the field, and competition in the marketplace is a much stronger place for athletes to be. The moment that they have to rely on bilateral monopolies, which is the traditional NFL, NFLPA sort of union bargaining, then it comes down to how willing are you to go on strike. And I just don't think, given there are people who are really, they're on the team as practice players. There are people who are on the team and they're great, but this is their highest level ever. And then there are people that are waiting to get into the next level. And those incentives are so different that very few of them are going to want to give up a year of putting film on, putting plays on film for scouts, or having their best year ever as a senior. That a strike is really hard. Sorry, I'm just going through all my notes here.
No, you're perfect. I want to jump in only and pretend
Yeah.
to moderate this conversation because it's amazing. You're actually capturing something. The idea of the smaller bargaining unit is almost a historic idea in sports, that it would incorporate the upstart league almost.
Yes,
That
it's
players
exactly like
only
having
had
an
success
AFLPA and an NFLPA.
when you had an AFL, NFL, and you could have some success with an upstart league. That's a remarkably good concept in a lot of ways. I think it seems to be one that the NCAA and others might oppose, just because I don't know why they would oppose that, but interestingly enough, and the other thing, it would also allow other conferences to probably find their own medium in that, though, wouldn't it? It would keep it the consolidation from quickening, I'd almost say. What do you
I mean,
think,
I think it
Andy?
would be a choice. It would be a choice of, well, how much do we want to spend on this sport to be competitive, which I know is a little bit weird to say, but like that's kind of it. Like there are computer programming coding companies out there that don't pay as well as Google, and they don't get as people who are as good at coding as Google gets. And we don't say, well, that's not fair. We say like that's good. And so
I work for one of those law firms that don't charge as much as some New York firms, and we say we do a good job for what we charge you. Yeah, no, I like that idea. Debbie, Andy said the magic words, and you're the one who's the most experienced in this area, the idea of being television content. And let's talk about the nature of the televised relationship as we move ahead. That's really the driver here, isn't it?
Absolutely. I mean, I wouldn't even call it television anymore, since streaming and social media and all that are taking point. I call it media now. But absolutely, I mean, look at the Big Ten's $7 billion deal that the athletes are getting zero of so far. So that is why there would not be there would not be a deal if the athletes were not performing in their sports and driving viewers to whichever media it is being distributed on. And that is why, to me, collective bargaining makes the most sense.
Brandon, I wanted to come to you on that. Obviously, having been in a variety of roles and kind of setting that up, if the content and media is the message, is it important to have a lot of it or a little of it that's consumed? How do we judge that and manage that? And how do athletes particularly ask for a piece of that?
Obviously, from a collective bargaining standpoint, it's something they're going to have to negotiate how often they play, as if they're in the same vein that the NFL does. And the more that they play, maybe the more that they want a portion of the revenue that comes in to those big media rights contracts. It's interesting to think about, but there has been buzz, certainly from media and from behind the scenes, that maybe you remove your football program, make it a separate entity, and license out the use of the name, image, and likeness of the university, interestingly enough, and just make them employees. And there they can decide how much time they want to spend potentially going to class, maybe not going to class at all, or particularly working on their skills, as Andy mentioned, trying to set themselves up for the next level. And maybe for some of them, like it is now, that's the final level. So maybe instead of 4 years of participation, or as you see now, 5, 6, 7, 8 years of competition, this becomes a professional career for some of these athletes instead. It's a brave new kind of world concept when you think of it that way. But my colleague Dave Ridpath likes to say often, the fans are going to watch anyway. So I don't think it matters, quite frankly, from that perspective, from a consumer perspective, how often you put them on TV or how little you put them on TV. The relationships of our consumer base in college athletics are so tied to the institutions that I think even if they're employees and not students, that the vast majority of emerging generations are not going to particularly have a problem with that.
Andy, I'm going to offer a chance to get off the hook because I know your firm was involved in this case. On the other hand, I rarely know you to pass on jumping in, but I wanted to switch to the House settlement. I wanted to kind of get the views of the panelists on House, what it suggests to them, and how sustainable it may be. There are some who've been very critical of it, some who've been sort of positive toward it, and some who've been much in favor of it. Anybody want to start? And knowing that Andy can have the last word of the first, if either
Let me
one.
have the first word, which is to say that I really can't have any words.
Okay, that's what I figured.
Dying to talk, but I can't.
Why don't the rest of us dissect it? Michael, yeah, go ahead.
I'll start off quickly here. I think of it as the House unsettlement. The NCAA wants this to be the last antitrust lawsuit, the last legal dispute they have. Then they want to go to Congress and get an antitrust exemption. And you think about this, as we're talking, Google is being sued by the United States of America, and the Justice Department is thinking about breaking up Google as a proposed remedy. So what the NCAA is seeking is something that is who else can go before Congress and say, we have a multi-billion-dollar business and we're seeking an exemption? But I do think it doesn't close off all the legal outcomes. Real quickly, there's a lawsuit by the Attorney General in South Dakota. He's suing in behalf of the 2 NCAA schools there. He wants a ruling that enjoins the NCAA from subtracting revenues to pay for the House settlement. The payments would go to the power conferences. I mean, local courts tend to favor local parties. That would really upset the payment structure. It wouldn't directly affect the House settlement, but it would really put the NCAA in a very difficult financial position. That's one. Two, you've got this case Fontenot versus NCAA. That's Brett Kavanaugh's concurrence in Alston, which was a blistering labor critique. Alston had nothing to do with labor or work. It had to do with educational benefits. But somehow Justice Kavanaugh saw that as an opening to provide his labor critique. That sounds like something we could hire him at my school. I mean, he's just perfectly positioned to be with us. But in any event, they're going to test this labor theory. Now, we don't know if the result of the House settlement will be to extinguish that lawsuit. But there you've got 2 pieces of litigation. And we haven't talked about Johnson, and we haven't talked about Title IX lawsuits, which are inevitable. So this isn't the last chapter in the evolution of college athletics.
Mark, I saw you nod early on. Why don't I hear from you for a second before I come back with a couple of follow-ups?
Well, I don't think the plaintiffs' lawyers who are negotiating the House settlement are bad people. I think they care about what they're doing for college athletes. And I think there are big aspects of the settlement that are good. But there's one colossal problem with the settlement. And I know people have thrown out 1,000 problems. I don't think there are 1,000 problems, but I think there is one incredibly major one that derails the settlement. Now, Section 1 of the Sherman Act, antitrust law, says any contract, combination, or conspiracy in the restraint of trade is declared to be illegal. And that makes it illegal to have a wage-fixing restraint. It makes no difference if 1,000 member colleges get together and restrain wage with a salary cap of $0, or if 1,000 schools come together and restrain wage with a compensation of $22 million per school. They're both wage-fixing restraints, and they're both thus illegal. Now, the problem with the proposed settlement is one particular element of it where they agree to put in place what would be, in essence, a $22 million per school salary cap. That is just as much a wage-fixing violation as if it was zero. It makes no difference if people may objectively feel $22 million is comparatively fair. It's not about what people perceive as being fair. Antitrust law is a law of capitalism, a law about free markets, a law of libertarianism. It doesn't matter if we like this amount better, it's still not the free market wage. Now, one more point on that. You have 2 lawyers who are primarily handling the settlement. Jeffrey Kessler, who also was involved in the NFL NFL settlement to their antitrust violations, and Steve Berman, who was not. Jeffrey Kessler, who was involved in the NFL settlement, the White settlement, hasn't compared the 2. Steve Berman, who was not involved, keeps on saying this is the same thing as the NFL settlement in White, which established a salary cap. Simply stated, Steve Berman on this one particular issue is dead wrong. If you go back and read all of the pleadings in the White settlement, The question was addressed as to whether the salary cap put in place in white would be an antitrust violation. The same question I just raised. And the U.S. Court of Appeal, the District of Minnesota directly, and the U.S. Court of Appeals for the Eighth Circuit indirectly said it was not, and it was not a problem specifically because the NFL players recertified as a union and ratified this in the collective bargaining agreement, consequently making it fall under the non-statutory labor exemption. Now, that does not make White and House the same as Steve Berman suggests. It makes White and House 100% in opposite to one another. Because unlike White, where this was ratified in collective bargaining and thus fell under the non-statutory labor exemption, to the contrary, in House, there is no union and thus cannot fall under the non-statutory labor exemption. Thus, the settlement in House, at least the way I read the District of Minnesota decision in White, would be an ongoing antitrust violation, presuming that the wage fixing restraint at 22 million still violates antitrust law. And if you guys find a way to get around that, you're better than I am, because I don't see one.
If you, like me, for the last 30 years have been going to seminars presented by the sports lawyers, by the players associations and others, somewhere Richard Bertelsen is smiling, because he would always say that that was the condition of the White case, that we would have to reform and recertify as a union before that they would agree to settlement on that one. And that really was it. The other part that's an interesting one, and maybe this is a little bit of an inside baseball question, maybe best for Professor Leroy, is that for a while in our pro sports, we had special masters overseeing all our collective bargaining agreements as a result of these lawsuits that came up about decertification. That's not clear that's going to be the case in House, is it? And isn't there some value in having some adjudicatory authority? And you're muted. Sorry.
I should be muted more often. Let me just say that. One piece of the House settlement does seem to have an adjudicatory function, and that is this clearinghouse for NIL deals. So I do want to just pull that out as a possibility. But to really get to the spirit of your question, which is generated by Mark's observation about the contrast between collective bargaining in the NFL and what we have in the House settlement, there is this cap. And this is just, there's a tiny adjudicatory piece that is significant because the way college athletes are being compensated today is NIL. It's not direct revenue. It's so in that sense, you've got the adjudicatory structure that could come in, but the special magistrate that you're referring to, they would take grievances. For example, Michael Vick had this terrible problem with a conviction for dog fighting and so forth. And there was a technical issue about whether a $20 million bonus had vested because of the timing of his arrest and so forth. Very technical issue that kicked out to a special magistrate. And so in that sense, the entire collective bargaining relationship was minutely or broadly regulated under the auspices of the District Court in Minnesota, as Mark has indicated, and a special magistrate, professor at the University of Pennsylvania, would get these cases. That's not going to happen. And so to Mark's larger point, and I think to the spirit of your question, we're going to be left with a regime where college athletes and the power conferences are getting direct revenue, but they don't have a voice. They do not have a voice. And that's the fundamental flaw in this settlement.
I think that's a fascinating argument. I wrote an op-ed, that was not particularly deep, but it was an op-ed that's gotten a lot of attention, that so much hangs in the balance based on this presidential election. You alluded to that earlier, Professor Leroy. But Debbie and Brandon, could you lay out how you see the state of college athletics playing out in a Harris administration or in a Trump administration? And I'll ask you to do that kind of neutrally, without a bias or without any thought, to the degree that that's humanly possible.
I was just going to add another comment to the previous discussion. Why I don't love the House settlement is that it's not collectively bargained, and especially because it limits the upside of athletes. If you're limiting it to like a $20 to $25 million pot per school, whereas that's going to be a huge amount for smaller schools and may put some teams out of business, if not their whole athletic programs. When you're talking about the SEC and the Big Ten, it's going to be like a tiny amount for them with these multi-billion-dollar media rights agreements. And that's not even including sponsorships and ticket revenue. So you're really limiting the upside for the athletes, and they're not even collectively bargaining. It's being decided by, Judge Claudia Wilkin and some other
Yeah,
lawyers.
yeah, you're exactly right. The Penn State that I worked at and oversaw as athletic integrity officer was $180 million annual business. And we were different than Ohio State and Michigan, who were 220s and 230s, because they had a larger basketball revenue and a slightly better sneaker deal. But we were all sort of in the same boat. That as you move down the ranks, it's a very, very different boat size when you get there, for Jaws reference. I'm intrigued. I'm intrigued by and I was going to try to point to that. Brandon, you want to take the political question at all? How you see it playing out, depending on the differences?
I do, and I don't want to get too civics lesson with it, but it also depends, on how the House and Senate votes turn out as well. So it's not necessarily just about the executive function. And to Michael's point, I'm taking some notes as well, and just thinking about an antitrust exemption where, potentially the Department of Labor, the Department of Education takes over administration of the executive functions of the NCAA, or at least has some form of oversight. It's fascinating, but without getting too far down the road in strict kind of political differences. Certainly, Harris administration would continue some of the Biden efforts towards, for example, with the Johnson case, looking at whether or not athletes in certain sports, maybe in all sports, meet the designation of employees under the Fair Labor Standards Act. I think that would definitely continue under the leadership that's gone that way, particularly with the Department of Justice maybe being more active with looking at some of those antitrust activities, because that's a fascinating point that Mark brought up. If we have an antitrust violation, how come over the past 10 to 15 years, maybe 2025, nobody from the government really has done anything about it? I think that's changing. I think that would continue under a Harris administration. A Trump administration is a little bit more difficult to pinpoint exactly where, because of the nature of unpredictability that kind of came with the first term, and what was important and what was not. I think you would see more lobbying efforts, quite frankly, in a line with potentially Senator Tuberville's, former colleague of mine, his a piece of legislation, and what will go forward, which would be a much more measured version of what we're talking about right now. And in terms of government involvement, maybe would lean more towards this House settlement being status quo, and that setting the stage for whatever comes next. So I think if you, to put it in plainest terms, if you're the plaintiffs in the House case, if you're an athlete, maybe you're hoping, maybe not voting, but hoping for a Harris win. If you're more affiliated with the management side, with the traditional NCAA member institution side, you might be able to, I don't want to use this language, but stomach a Trump administration.
Andy, you and I probably had that conversation, at least offline, in some measure. If the last 20 years of college sports has been a battle of athletes wanting to assert greater rights and a greater share, would that how slow would a Trump NLRB or a Trump administration, how much would that movement slow? Would it be permanent? Would it be for a period of years? How do you think it would go?
Yeah, I mean, I think if we can imagine it, it isn't very pleasant to me to do. Ted Cruz, at the head of the Commerce Committee, Senate Commerce, putting forward a bill saying that college athletes cannot ever be employees. A president who has bragged about, firing striking workers doesn't seem like someone who would veto that. And so I could see, it's the election's on a knife's edge We could have all three branches of government in control of organizations that don't particularly like seeing, to be frank, young Black men with a lot of money, and don't particularly value labor rights as a concept, deciding the labor rights of young Black men. So I think it could be dangerous. But I also don't think there's very many people out there that are voting on that issue. So it's almost like it's going to be like a collateral damage to larger culture wars. But it's really, I really think it is the main reason why I always ask, why hasn't the NCAA done the obvious thing and voluntarily recognize a union that would be supine and set up a situation where they only have to give them, oh, I don't know, 22% of the revenue or something like that. And that's way better than any other option. But I think except for this option, the Project 2025 option, that is out there and would set the clock back to, when Billy Packer was in charge.
Julie Summer and I have who was on the first panel today, and I had a conversation about just where Title IX fits into this larger framework, and I think Title IX could be one of the, again, in a Harris administration, one of the more determinant factors. How do you see Title IX, any of the panelists right now applying in the future to college athletics and compensation? Michael, you put a finger up. Go ahead, and then Brandon, I think, had a
quick
on
observation, because we've talked about politics. We haven't talked about the Supreme Court, which is a political institution also. This Loper-Bright decision that overturned what's called Chevron deference, that already is in place, and that could shake Title IX regulations to their foundation. I think it's important for our listeners, our participants, to understand Title IX is a one-paragraph statute that prohibits discrimination in all educational benefits to institutions that receive federal funds on the basis of sex. That's all it says. So it needs a lot of articulation from the Department of Education. And so every administrative guideline, from the controversial transgender guidelines to the mundane ones about proportionate, resources for women and men in athletics, they're all subject to now a hostile lawsuit and a favorable environment for overturning them. So I just want to put that sort of underpinning into our conversation.
That is a fascinating truth and absolutely true. It feels like. Brandon, did you want to add anything?
Yeah, just I was having a conversation briefly in class about this earlier today, which is the Government Accountability Office releasing a report this year that most large institutions are likely out of compliance with Title IX. And even 20 years after the conversation about do we still need Title IX, and 2 years after its 50th anniversary, it is fascinating, Michael's point, that it's possible we need Title IX and the associated regulations more than ever. But quite frankly, because of the changing political dynamics and because of the makeup of the Supreme Court, and since nowadays it seems like any controversial issue is going to get a green light to that normally restrictive body, I'm kind of scared for the future of Title IX.
Enjoined, right? Yeah, as it is right now in Texas.
Yeah, exactly. And there are a host of ancillary issues that come with that, but from a purely participatory and for the purposes of our conversation, collecting in the settlement revenue, I'm not sure what the institutions want to do to make it work. In terms of equity, it seems very, very simple that $22 million, if it goes through, half of that should probably be going to schools. But when you look at the numbers, particularly what the Government Accountability Office is looking at, that's probably not going to be the case.
Certainly the backward portion isn't being attributed that way either in that settlement. So it's a fascinating one. I wanted to get to the story that kind of made some news and we've talked about in and out of our day-to-day, but it's the Sluka UNLV case. The idea that an athlete decides to attend a school based on a promise, then ultimately leaves to preserve his one thing. Is Sluka the Curt Flood of college athletes right now, or is he or is he a young man described as a quitter? And Debbie, you are in this space, both educating and representing coaches, and maybe occasionally an athlete crossing this. Maybe you and Michael Chapman would take your first cut at this.
Yeah, I mean, I was actually on a radio show about this last week. I mean, I'm not surprised. As I said, we're in this gray area. So much is not not documented. There was no agreement. And I'm sure there are other athletes out there in a similar position. Another UNLV athlete has also gone into the portal for the same reason. And there's no registration or oversight of NIL agents. Anybody can hold themselves out to an NIL as an NIL agent. Somebody DM'd me the other day saying, look, this guy is literally a used car salesman who's representing a football player. So, unlike the NFLPA, the NBPA, where everybody is certified and has to either take an exam or at least be approved by the union, literally anybody can hold themselves out to be an NIL agent. So there's athletes and parents getting bad advice, and things aren't necessarily documented with collectives because is it NIL? Is it salary? It's not part of the university, but sometimes coaches are directing. In this case, they allegedly weren't directing. I mean, head coaches can be liable for what assistant coaches do, but it's all a very gray area. So to me, it was very not surprising.
Michael, any thoughts from Chapman? Any thoughts for you?
Kind of along those lines, I think that's a scenario that kind of points to kind of the overall framework of this entire session, which was there will be lawyers, and it kind of speaks to, at times people might not love lawyers, but there's a reason lawyers exist, and there's a reason they need to be involved. And so you hope in this scenario, at least moving forward, that you can get some sort of, and I think it would come in the form of, if you had unions, you could get this benefit of the unions then certifying agents, and agents having at least some level of responsibility and ownership and desire to serve their client. Now, we can go look at the NFL and the NBA, and we know that not all agents are doing exactly what's for the benefit of their client at all times, but it's better than a used car salesman acting in that role who is not under some kind of certification or some kind of requirements in order to serve that. So I think, kind of going back to our overall theme, there will be lawyers. There are things here, even if we get to the settlements and we get to the unions and we get collective bargaining agreements and things like that, it might trigger more involvement from attorneys from a perspective of, how are we going to certify agents? How are we going to do things? A big part of the work I do on a day-to-day basis is athlete safety. And athlete safety isn't just physical safety. We need to be protecting athletes, because we're talking about 18 to 22-year-old young men and young women, and they're starting to get lots of money, and there's lots of money available in this space, and they need advisors. They need people who are helping them. And I hope, my hope, and it's not going to be 100% true, but my hope is there are more good attorneys and people working in this space trying to benefit the athletes and work on their behalf than there are bad actors making it even worse just because they see a dollar sign at the end of the day.
I think we've come to sort of the end of our time, that they're going to start playing us off like at the Oscars. I want to say thank you to everybody. You were brilliant panelists, and I could stay an hour each for each of you. You were wonderful. Andy, I'm going to give you the last word because you endured an hour with a bunch of lawyers.
Without charging.
Without charging, which is impressive, and not even, and probably for testimony time today. So so I'm going to give you the last word for the panel, and I'm going to come back at the end of that and say goodbye. Thank you.
Well, so this is contrary to my business model, but I think the best use of lawyers is to prevent lawsuits, and not have to hire me to come in and work on your case for you. And I think that the gray areas that are created, I think intentionally by by management here, by the NCAA, by the conferences. Oh, everyone knows there's inducements out here, but tell the athletes that they can't sign the deal because maybe that'll cause a problem with their eligibility. Like, if we were in a regular, normal employment situation, or call it a royalty situation if there's some religious reason why you can't have employees, but a situation in which simple standard contracts, and I don't mean the same amount, but the simple terms, have organizations out there providing appropriately scaled legal advice in terms of price and things like that to the size of the contracts. Everybody would be better off, and you'd get the lawyering out of the way at the beginning, in a way that I think is conducive to creating more commerce, which, is good. I'm very pro-commerce.
As anyone who's ever practiced law, you've just articulated maybe our first wish as lawyers. If only if our clients brought us in at the beginning, we might have solved this problem at the end. Unfortunately, I've reached the end with this extraordinary group. Michael Chapman, my colleague, and it's so wonderful to work with you and to do this with you. Brandon Wright, you're as brilliant and wonderful as I've always remembered you to be. Debbie Spander, there is a reason why you've been the head of the Sports Lawyers Association, and you well should be. You've earned that right, and you are a special, one of a kind player. Mark Edelman, I'm always impressed to work with you, and your infinite knowledge of antitrust law is extraordinary. Michael Leroy, it's a pleasure to finally have a chance to talk with you and interact in a public forum with you. I've admired your work for forever and I'm so impressed by it. And Andy, you remain a treasure as a truth teller, as one of the most interesting people ever, and you're the greatest gem to moderate because you hardly have to do it. Thank you, everybody. Thank you to Culture and Sports. Thank you for today. If you've been listening and you've not fallen asleep out there, thanks again. And this recording will be available, and we'll do this again sometime soon. Thank you.
Thanks, Bob.
Thanks, Bob.